Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello. Good evening. Good evening, my friends. Today's Tuesday, January 28th of 2025, and we're back at it. We're back at it again. For those of you who are not here earlier today, we did a couple of hours reading the defense's opposition to the Commonwealth's motion to exclude the testimony of defense expert Richard Green, and to also ask the judge to say, hell to the no, we're not giving you a Daubert hearing, because not only is Richard Green, not only is Richard Green qualified, he's more qualified than Ian Whiffen and Jessica Hyde, maybe even put together. Therefore, how dare you, basically. We didn't get to finish Richard Green's affidavit, which in my opinion, having read the entire thing now, is so much more interesting than the motion. So if those of you, we were on a cliffhanger, those of you who have not read that yet, we're going to finish it. Let's bring Mark Bederow on, because he's chomping at the bit to talk to you guys. And we have so much to go over tonight, because it's been a hot minute since Mark and I were together.
We were.
Hello.
Those of you who have not read that yet, we're going to finish it. Let's bring Mark Bederow on, because
I think I'm playing on your end.
I have a sound problem.
Through your speaker.
Since Mark and I were together. We were. Hello.
All right. So wait, do you have...
We're going to finish it. Let's bring Mark Bederow on.
Oh, it's... Okay, here's the problem.
I have a sound problem.
Through your speaker. Mark and I were together. We were. Hello.
You have headphones? Because my sound is going through your speakers and then it's coming back into the feed, right? Can you guys hear that? Because it's on a delay. You know what? Close it. Do you have YouTube open on your browser? Can you close YouTube? Because my sound is going through your speakers and then it's coming back into
I do not
feed,
have
right?
YouTube
Can you guys hear
open.
that?
You want me to just close out of this and come back?
Yeah, it's echoing.
You know what? Close it.
Do you have YouTube on your phone or something? Like, it should not.
Let me just close out.
Okay, come right back. Yeah, I don't know what was going on. It was kind of like, sometimes if you have YouTube open in another tab, it'll play, and because there's a delay, I don't. We'll figure it out. Let's take a look at some of this while we're waiting for Mark to come back. The affidavit that we did not get to finish from earlier. Oh wait, here he is. Oop. All right, let's try it now.
Better?
Yes, that's better. Okay.
How are you?
Okay. How are you?
Good.
Good. Here we are. It was 3 years ago today that John and Karen went to CF McCarthy's and then went to the waterfall.
Wow.
3 years ago today. May John O'Keefe rest in peace. I mean, what are we doing here?
It's a long time for a criminal case that's nowhere near done, too. Wow.
I mean, I've seen cases go longer. There's a case right now. Actually, do you know that Judge Cannoni is right now hearing a bench trial for a woman named Penny McGee?
I heard about it. I don't know much about the case other than some woman is accused of killing her husband.
Well, her ex-husband, his name is Andrew Savitz. He ran Dukakis's 1988 presidential campaign.
It's probably not the first thing you'd want on your resume, but it's certainly, he's politically connected for sure.
Well, here's the thing. His ex-wife goes over to confront him because he's trying to evict her from her house. She goes over to confront him. He had had a stroke 6 months before. He had like severe coronary artery disease. She's arguing with him. He has a heart attack and dies. They're charging her with manslaughter.
Because he had a heart attack and died?
Yes. Because the medical examiner's report has the cause of death as arteriosclerosis, hyper whatever event, secondary to an argument. I'm paraphrasing.
God bless Norfolk County, huh? Jeez.
And Larry Tipton, who's trying the case for the defendant, is also Brian Walsh's attorney. They elected, I think it was this morning, for a bench trial in front of Judge Cannoni instead of a jury trial. Probably rightly so. However, you have been a big proponent of the bench trial for a very long time, unless it was Judge Cannoni. So it's going to be very interesting.
Was there a motion to dismiss for lack of causation in this case?
I haven't even dug into it to that extent because it just started today and somebody just brought it to my attention. But I can't even, how are they going to prove causation?
It's tough to have a homicide case by yelling at someone reasonably,
She may have pushed him. She may have slapped him. I'm not really sure. The daughter testified today. Her testimony was all over the place because she testified to a lot of stuff she did not tell Yuri Buchanek in her statement. So this is going to be interesting.
Wow.
Yeah. But anyway,
cases.
Back to Karen Reed, because there are shenanigans everywhere in Norfolk County. This is like the twilight zone of the universe. It's like the armpit of the United States, basically, because what are we doing here? Richard Green. What the what? Let's go. I know that you read the papers, and I read the papers too, the papers, but a lot of people did not get to see the anomalies that Richard Green brings up in the end of his affidavit. So if you guys were here with me earlier, we went over the opposition to the motion. We went over Richard Green's affidavit until I had to run and be the mommy Uber. Here are the salient points so far. It was pointed out on page, where was it that Ian Whiffen emails Richard Green in April of 2024 while the trial is going on.
That's on page 6.
Page 6. Okay. On April 22nd of 2024, the Commonwealth's expert Ian Whiffen emailed me meaning Richard Green, this is Richard Green's affidavit, stating the last visited time.
Sorry. This is, I've never seen anything like this. I'm sorry.
Yeah. Let me read it and then you can give us your thoughts. So here's what was going on here at this time. We're talking about the 227 Jen McCabe phone search because, maybe Jen McCabe didn't make the search. Maybe her phone just made the search, or maybe somebody else touching her phone made the search. But in Richard Green's affidavit, we're already on page 6. He's talking about all of the different software that he used to confirm this 227 search. And then he goes on to say that the most recent version of Axiom even gives him a tighter timeline on the 227 search. It's even better now. It's even more specific. But here he's talking about the Axiom version 6, which is what his initial analysis was. This is the Axiom forensics version that was initially used by him because that was the version that was in effect at the time. Search long, Haas long to die in cold. Last viewed date and time was 1/29/22 at 2:27:40 a.m. Here's the URL. The source was a Safari suspended state tab. The state was deleted and the type was a WAL file. Celebrite processing. In Celebrite Physical Analyzer version 7, the 22740 AM Haas-Long to Die in cold search not only showed up in the web history, but Celebrite further refined the results and included it in the searched items artifact section. It was marked as a deleted record with an adjusted last viewing timestamp of January 29th, 2022 at 227:40 a.m., which is UTC -5. Noting the inconsistencies in Celebrite's reporting between the UFED report generated by version 7 and Celebrite's Physical Analyzer version 7, I contacted Celebrite's technical support to inquire if they could provide additional information about this artifact. Celebrite's technical support staff indicated that they believed the artifact was reliable and that no issues had been brought to their attention. He doesn't say when he contacted them, but then on April 22nd of 2024, which as we all know was during the trial, during the first persecution of Karen Read, the Commonwealth's expert, Ian Whiffen, emailed me, meaning Richard Green, stating, quote, "The last visited time shown in PA will be getting removed from the artifact in the next available version of Physical Analyzer 7.69. After the start of the trial in this case, in late May of 2024, Celebrite released Insayet's Physical Analyzer version 10.2, blah, 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 which removed the 2:27 a.m. timestamp from its processing of the artifact. And then shortly after the trial, on July 22nd, 2024, Celebrite released its Celebrite Physical Analyzer Standard V7, which also removed the 2:27 a.m. timestamp from its processing of the artifact. Notably, Celebrite is a company that markets itself as providing digital intelligence solutions for law enforcement and is used by over 6,900 public safety agencies in over 100 countries worldwide. Talk to me. Talk to me.
Well, the mere fact of a prosecution expert witness on a murder case emailing a defense expert witness on said murder case after the trial has started without more is so off the wall what is happening here that's just crazy, and without more would even suggest, and I don't remember how many times Ian Whiffen has testified
Once.
as witness. Well, yes, that's kind of my point. I was going to say either 0 or under 5, because anyone who understands the protocol and decorum at a trial would recognize that what I should not be doing is having email chit chat about the substance of the trial with a defense witness while the trial has started, if
Right.
at all.
Right.
Then, but I guess so back up. So that's just, wow. Then you look at the substance of the email and it gets even worse because, the last visited time for Richard Green is at 2:27 and however many seconds. And that's important. That's part of his conclusion, whatever, to determine that the search was made at 2:27. And in essence, what the prosecution expert is telling him is that, that technology is not valid anymore. Let's get down to brass tacks. That's what he's saying. He's saying this is not credible science. And some might even say that's a version of witness intimidation. I wouldn't say that because I'm not that into the whole Massachusetts, everybody commits witness intimidation. But how else could you interpret this other than the prosecution expert saying, hey, buddy, your opinion is not reliable because you're relying upon something that's not reliable. It doesn't mean he's being nefarious. Doesn't mean he's not either.
Mm-hmm.
But clearly, the only reasonable interpretation of making that email would be to suggest that any reference that you make to last visited time as part of your expert opinion is flawed and wrong. And for the prosecution expert to be, man to man emailing the other expert and saying that, to me, is designed to make the defense expert lose confidence or doubt what he's saying. And this is just really inappropriate, whether, again, the inexperienced witness meant to do it or not. How the hell this could happen is beyond me. And the real question you'd have to ask is, did he do that on his own, or did the prosecutor have any knowledge that I would certainly hope not, because if the prosecutor allowed that, that would be outrageous misconduct.
This is exactly what I was thinking. That something is so funny. Annie Bev says, if I recall correctly, the question allegedly got escalated to Whiffen within Celebrite, separate from his role as an expert for the trial. Do you think that he just had no idea who he was talking to, and that he did not know that Richard Green was the defense expert in the Karen Reed trial, and that he just thought he was emailing a customer?
No, I can't accept that, because as the prosecution expert, he would be familiar with who the defense expert is. You review the work. You talk to the lawyer on your side about, does this make sense? Or what are your thoughts? What's right? What's wrong? If that were the case and he literally had no clue, then that just tells you, again, what a shit show this is from the prosecution side. On the other hand, if he's calling as, the Celebrite or software representative or expert on the subject matter, who ends up being a witness when he has a financial stake to some extent in some of what Celebrite is doing, is another, possible problem for the prosecution that I expect will be also brought out, as I would expect this email. I mean, this never happens in 27 years or whatever it is. I've never seen an expert witness in the middle of trial start having substantive chit chat with the other party's expert and basically tell him, you're using, bad technology, don't do it. Or, just so you know, whatever you're relying upon won't even be valid in a month. What else could he be saying other than, if you do that, you're using science that's about to be discredited? That's not Whiffen's place. That is the prosecution's place on cross-examination of Richard Green to say, are you aware that programs change, and have you heard something is in the works? And then you go from there, whatever Green would say or wouldn't say. Maybe he's not aware. And if the prosecution can introduce facts to show that it is being changed, I think that would be an appropriate, fair basis for cross-examination. But having a witness call another witness and tell them you're using bad technology is tantamount to witness intimidation under Massachusetts's crazy witness intimidation laws. There's an intent to get him to change his testimony.
It is an incredibly broad statute, one of the broadest statutes I've ever seen.
I'm not suggesting that it's seriously the kind of thing that would literally result in witness intimidation. But what I'm saying is this is ridiculous and should not have happened. And it doesn't even matter whether it was nefarious or not. You can't have prosecution expert witnesses emailing defense expert witnesses in the middle of a trial saying you're relying upon outdated and invalid software. That's just not appropriate.
It is just wrong. And to clarify things, Ian Whiffen is not testifying as a representative of Celebrite. He is testifying as an independent expert witness for the Commonwealth as his own side gig, correct?
I believe so, which just creates more trouble and makes you say, why him? Again, that's not even an attack on his skill set, but is there nobody else that you can get who doesn't have those kinds of business entanglements or possible interest in the outcome? I mean, you're making an expert witness who generally would have no interest in the outcome of a case. Doesn't mean that Ian Whiffen does have an interest, but you're allowing the inquiry that if he is correct and the jury believes that he's correct and it helps them win the case, he potentially stands to profit financially because his software carried the day. Mm-hmm. So there are all kinds of entanglements that you would, as a prosecutor, you just wouldn't call someone to have those kinds of issues. And the fact that they're calling someone like that, again, has nothing to do with his skill set. Is there no one else they can get to do this? Is there no one else other than the guy who emailed the defense expert and said, don't use junk science?
Could they maybe find a guy who has testified more than once in his life, in his career?
Again, there are so many just oddities and bizarre events that attach to this case on a daily basis. And most of them just seem to come from the Norfolk DA side. And at some point, how many of these oddities and coincidences do you accept as just being oddities and coincidences? I mean, it's truly, this is amazing. This little sentence about this email is incredible to me.
I don't have the Google. I can't Google it right now. But does anybody know the date of Ian Whiffen's testimony?
I think it was.
If anybody can find. I think it might have been after April 20. Like, I don't even remember, and I do not remember this ever being brought up at trial.
I can't imagine that he testified in April. So, I mean, either way, in theory, the defense would have had this email. I mean, by the time Green testified. So
Right.
What they did with it or whether they were aware of it, I don't know, but it's hard to fathom that Green wouldn't call the lawyers and say, yeah, I got this really weird email from this guy named Ian Whiffen who's telling me, my science and software is wrong.
It's certainly bizarre to say the least. This was another interesting little tidbit here in footnote number 2 on page 7 that says, I would also note that Trooper Nicholas Guarino's report labeled Norfolk Canton MFP CNF whatever, a whole bunch of letters, specifically mentions that he also used the Axiom product to process the forensic image of Jennifer McCabe's iPhone. I personally tested the earlier version of Axiom, which would have been used in February 2022, and determined that the 2:27:40 a.m. version of the Haas Long to Die in the Cold search was reported by Axiom as having a last viewed time of 2:27:40 a.m. Axiom has a similar feature to celebrate with their creation of a portable case, in quotes. This exculpatory information was never turned over to the defense. Thoughts?
Well, I think you're underselling it by just calling it interesting. This is,
my snark. It's sarcasm.
This is potentially devastating to Guarino's credibility, but more importantly, I mean, Guarino's the guy who's going to be literally hit in the trial about this stuff, but don't lose sight of the fact that from the defense standpoint, this isn't about Guarino. This is about Jennifer McCabe, okay? Mm-hmm. And all of this is going to come back to her in the sense that if the jury is willing to accept as a reasonable possibility that search happened at 2:27, they're not going to be looking at that fact in isolation. They're going to go back and say, well, wait a minute. Jennifer McCabe testified under oath, unequivocally, emphatically, without hesitation, I didn't make the search. If the jury is concerned that she might have made the search, it logically follows that same jury is going to say, well, the witness, meaning Jennifer McCabe, might possibly have perjured herself about making that search. And then they start looking at it with the other deletions, the butt dials that come around the same time, her general lack of emotion towards John O'Keefe at the time the case happened, and her presuming we're going to get more really strong emotion about how upset she was on the stand. And of course, if McCabe falls apart, then the whole house of cards comes crashing down and it's over. So you look at this, going back to the footnote, and if this is accurate, and presumably Green is going to say that I used the software that I was told would not reveal this, and you have to look at it in the context. So Guarino turns in a report that doesn't mention the search. Richard Green, apparently even the prosecution would have to concede, even though they think he's debunked and not credible, or I shouldn't say they believe, they've decreed, if you will, in their motion.
Yeah.
Putting all that snark aside, if they believe that Guarino was accurate, Green somehow found the search on a later program and then decided to go back on his own. In other words, exercise due diligence and see, well, why, what's the difference between these programs? And he found it on the same software that Guarino allegedly used. If that's accurate, and I don't think there's any reason to believe that he's literally making that up, that leaves a really bad either A or B for the prosecution and Guarino. The good version, or I should say the better version, because both of these things are really bad for them, but the not as bad, I guess, is that Guarino is just like Trooper Paul level incompetent. He just didn't do it. Now, of course, if that's the case, that calls into question his competence on a number of other things, like the so-called 3 stairs that he claims happened from them driving, which anybody with an Apple Watch would say, you got to be kidding me. I mean, I'd be looking for jurors as the defense for people who are into fitness and wear Apple Watches and understand how, stairs are counted.
Right. It doesn't come from going over a hill in your car and waving your phone around.
It may go up a really, really steep hill for like a steady incline, like when you're walking or running for a long period of time, but not that. So that's not a good option. But the other option is that he just did it on purpose. And if he did it on purpose, well, now you're getting into intentional misconduct, which presumably, you'll see when they file this motion that is coming up. I assume this will be referenced in some way or not. But of course, if the defense didn't know this at the time of the trial, and I don't know the exact timeline of when Green figured this out in terms of the other program, I don't know. But if that wasn't disclosed at the proper time before trial, then that's a Brady violation. That evidence clearly is exculpatory. If there's a search at 227, that's certainly, when you analyze Brady, is it favorable to the defense? Well, obviously, right?
Yeah.
The second element of any kind of Brady claim was it suppressed, which in a legal sense means was it not disclosed or otherwise known to the defense? Now, again, I don't know the timeline, but if they didn't know at the time, then it would be certainly suppressed. And then, of course, is it material? Does it matter? And they could have presumably clobbered Guarino with this. And it all would come back to Jennifer McCabe. So that would certainly make out some kind of Brady claim. If it's intentional, obviously that's even worse. There could be sanctions at issue combined with everything else. We'll have to wait and see what the explanation is. But why would anybody seriously doubt that Green is literally making up the facts that are alleged under oath in this affidavit, which leads you to believe in the best case scenario, Guarino just screwed the pooch beyond belief on this. But I don't think anybody's going to seriously believe that. I think most people would believe that if it's just a matter of using a program and searches come up and you just happen to miss the biggest one in the case, and I know you haven't even gotten into the hash values yet, we haven't gotten into all that stuff. None of this gets looked at in a vacuum here. There is a strong argument that's being made here to suggest that the evidence that was provided to the defense was to initially, in the first instance, conceal that 227 search and then perhaps tamper with the evidence to then get, Whiffen and Hyde snookered into supporting what they wanted. Again, these are all allegations, but they're not exactly making this up out of whole cloth. I mean, there appears to be, based on this affidavit, a lot of there.
I would imagine that anyone who's got access to Jen McCabe's extraction and this earlier version of Axiom could easily test this theory at home. I mean, this is an affidavit. This is not a report that is not sworn to. This is sworn under pains and penalties of perjury in Massachusetts.
I don't think Richard Green is, first of all, you have to be the type of person who's willing to do it in the first instance, willing to just literally lie as a matter of morality to do that. He didn't strike me as that kind of guy.
No.
He seemed like a gentleman, whatever you believe of the credibility or lack thereof in his substantive testimony. So I don't think anybody believes he's making this up.
But if
Just to say, finding the search on the program, I don't think that takes a hell of a lot of skill for somebody who's trained in what they do. So the question then becomes to Guarino, how did you miss it?
How did you miss 32,000 text messages on Farwell's phone? You know, this is a huge problem. He is their guy. He is the Norfolk County District Attorney's office trooper that is assigned to the forensics stuff. Isn't that that's what he does?
At least for now. I would probably, when this case is over, I would doubt it. But yeah.
It's a problem. It's wild to me. And then it goes on to talk about, all right, here's his first, it is my opinion, his first opinion. It is my opinion based on a reasonable degree of scientific certainty that the user of Jennifer McCabe's cell phone searched Haas Long to Dying Cold at or before 2:27:40 a.m. I have also consistently reported the existence of 2 additional search artifacts found on the forensic image of Jennifer McCabe's iPhone, which suggests that the user of Jennifer McCabe's iPhone 11 made 2 additional similar searches later that morning on January 29th, one at 6:23:51, how long TI die in CIKD, and then at 6:24:18, Haas Long to Dying Cold again.
Before you get to the second part, I mean, you also have to consider just the context of why are we even talking about this? And you're talking about this because you have really a silly motion to exclude him on Daubert grounds. And you know, you could go stronger than that and say, let's be honest, it's frivolous, okay? Yeah. The motion is frivolous. It's frivolous in that it was knowingly submitted without an affidavit and with the prosecution saying, you know, we'll pinky promise you, judge, trust us on this. Our guys say this, theirs is a fool, he's debunked, and take our word for it. They know that's not a basis to exclude the other side's expert. Okay, that's ridiculous. But then you realize, you know, when you look at his affidavit and there's pages of his qualifications, okay, and more importantly, there are pages of his methodology, what he did, and everybody knows who does this for a living. You've probably done a million Daubert hearings in your civil practice where they actually come up more. Right. The idea that any lawyer with a straight face would say, I have a legal basis to exclude as opposed to expose on cross-examination and argue, that this is a waste of time. This was frivolous. And all it did was invite this response, which is, you know, making things 1,000 times worse for them publicly at this time. But I mean, I think people can't lose sight of the fact that all this stuff about Guarino and everything else that you're reading about now was in a context in which the DA with a straight face was arguing, this guy's not qualified and he's been debunked. I mean, that's the title of the motion, debunked. Yeah.
Debunked opinion, and the opinion part was in quotes, not the debunked part, the opinions part.
These are experienced lawyers, okay? They know what a battle of the experts is. They know the role of a judge is to be gatekeeper, to make sure that I'm not dealing with junk science. I'm not dealing with an unqualified expert. I'm not dealing with a crackpot whose methodology is flipping a coin. And then whatever their opinion is, I don't really care. That's the judge's role. I mean, you saw that with Russell, same idea, right ruling, similar waste of time. But this is
a paragraph that didn't need to be there.
You know, look at all this, you know, you could say this is even worse. I mean, this is just frivolous on its face. And I wouldn't be surprised if they even sought sanctions for this. I mean, I know they're looking for money for the nonsense with the video that they're dealing with, but and by the way, props for the references to calling this Orwellian. I'm a big
I know. I was going to say that.
Fan of citing Orwell in legal writing and Kafka when appropriate. This is more Orwell than Kafka. I grant them that, but they are very politely angry, as you could see. And this is the kind of writing that you see that sometimes is followed by asking for sanctions. I mean, you could see that they're very upset about having to waste their time really discussing with a straight face as to whether Richard Green is qualified. And the answer is, of course he is. And the answer is, He used common methodology that, for whatever reason, Ian Whiffen and Jessica Hyde disagree with. The irony is, in this very strong affidavit and motion in response, what Green has done, the defense has done, is put this more in play than, the defense, the prosecution is trying to say, oh, this is a joke, this is garbage. And you have to consider another overriding principle at all times when you think of this. Mm-hmm. This issue is literally house money for the defense. They don't have to win. They don't have to convince you that this Google search was made at 227. All they need to do is establish that it's possible, that jurors say that could be. If they do that, the DA is in serious trouble. On the other hand, the DA has to literally obliterate Green. They have to wipe it out. They've got to establish to the jury there is no doubt whatsoever that Jennifer McCabe did not make this search at 227. And if they do that, they don't win. They wipe the sweat off their brow, take a deep breath and say, all right, we're still in the game. We've plugged one hole. What's the next problem we have? And what you have here is the witnesses who are supposed to do that are Ian Whiffen, who has, a financial interest in the software, who's emailing the expert, telling him this is wrong, who ironically didn't use as many programs that, Green did. You have Green saying that, none of us got proper hashtags. We don't know that the evidence was properly secured before it got to us. There are independent numbers associated with the searches. We had Whiffen saying, well, some of those searches may not have connected, so they might have come up later or whatever. And then you have Green saying, well, actually, the 623 search is about like how long to digest food, has a picture with it, which means it populated. So in other words, all Green has to do is make this plausible. And the DA is going to push back with Guarino and the other two experts who did not get the full source of data that they should have gotten. They didn't get those unaltered hashes. They didn't get all the things that, you talked about or you will talk about.
Guess that, yeah.
The one search out of 4,560. It just happens to be that one that's deleted. I mean, Jesus Christ, that's really...
Yeah. Let's get there. This is what I call a duck around and find out motion. Okay, you want to make this motion? Bring it. Because now there's so much more ammunition in this. Because Richard Green, despite his kindness, he seems like a very kind man. Don't ever mistake kindness for weakness. That's a big mistake. Because now he's like, oh, you're going to call me a liar? You're going to question my qualifications, my credentials? You're going to question me? Okay, how about this? How about this? I'm going to now go out and I'm going to even do some more research.
Yeah.
I'm going to use some newer programs and I'm going to prove to you that this search, not only was it made at 227.40, it was made at 227.40 point whatever the extra three numbers are on digits are on that, based on the newest Axiom.
Don't forget, again, Green can only talk about what Green knows, but very skilled lawyers, when the time comes for summation and when they marshal the evidence, are going to have other ammunition that makes Green's theory more plausible, which is what they really need, right? It can't be ridiculous. And when you talk about butt dials at 223 and 224 and alleged Google search at 227 and everything else going on with these people that were inside 34 Fairview Road, and I'm not talking about committing a murder or anything like that. That's not, I'm talking about their really weird and suspicious behavior around the exact time that this Google search, according to Green, was made. I mean, that clearly is going to move the needle towards plausible, which is all the defense has to do here. This is a real problem for the prosecution.
But now I'm the way I'm reading this, and we're not even halfway done with it yet. I mean, we're maybe halfway done. There's so much more evidence that it really, 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 in fact, did happen at 2:27 a.m. So now it's not just reasonable doubt. What they've done by making this motion is solidified, in my opinion, the 227.40 point something, something, something search actually happening. And we're going to find out why, because opinion number 2 of his is, it is my opinion based on a reasonable degree of scientific certainty that the 2:27:40 a.m. search artifact for Hoslong to Diane Cold was deleted by either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual.
Yeah, that's just politically correct, saying Jennifer McCabe tossed it, freaking out, or Guarino or someone in the state police deleted it to suppress it. I mean, that's what he's saying.
Yeah. I mean, it's a very kind way of saying either she did it or they manipulated the data, because they gave them a PDF of the hash values we're going to see. It's like a PDF. It's not even like the original extraction.
Well, there's been a lot of PDFs in this case and screenshots and things where, one might expect real evidence.
None of it's the best evidence. None of it's the best evidence. We saw so many things entered into evidence in this trial that were not the best evidence. And we were screaming during the trial, screenshots, inverted videos, all kinds of ridiculousness that we would never, ever see in a New York courtroom. We just wouldn't.
No.
Right. And it's not like we're throwing shade on Massachusetts. It just wouldn't happen here.
Well, throw a little shade on Massachusetts.
I was trying to be nice.
I'm from there. I can do this, I guess.
Okay, good.
You and I both know that in a New York courtroom, the inverted video, forget that it was inverted. It was belatedly disclosed in the middle of trial when they had notice of its existence for basically since January 29th, 2022. And they turned it over in April of 2024 in the middle of trial and said, have at it. And then they tried to snooker everyone by telling them that it was, legitimate and, nothing to see here. Yeah. And, everybody but, the one guy who got all excited about, there's the right taillight on YouTube, realized that something's wrong here. In a New York courtroom at a mistrial motion for just an egregious, what we would call Rosario violation, which is a discovery violation. And certainly because of the inverted nature of it, it would be exculpatory, it'd be Brady. There isn't a judge, certainly in Manhattan, probably anywhere in New York, who would not look at the prosecutor and say, you tell me right now why I am not ordering a mistrial, okay? Mm-hmm. So, the jury's going to go home, and then I'm going to give you a week to come back and say you got a larger problem. You tell me why I'm going to find a manifest necessity to grant you the right to retry this due to your egregious and deliberate misconduct. And the answer is it wouldn't happen, and this case would have been kaput right there.
As it should have been. How did that duck-in video even get up on the screen in the courtroom? How did it even get on that screen? How were they even allowed to press play in front of a jury?
I know you and I didn't talk about this when that motion came out the other day.
Well, we're going to talk about that after this one. So we can, but yeah, go ahead.
Lally needs to testify at a hearing. I mean, the defense, when they file the motion, you need an evidentiary hearing, and you need all these people up there, and you need them testifying. And, Lally's the one who's going to have the problem here because, the buck stops with him. He ran this from day one up until all of this, and there's video getting turned over before the trial that's not complete. There's, half videos with people jumping in and out of walls and inverted and poor quality getting inverted, getting turned over in the middle of trial. And then just for good measure, just to kind of complete the circle when the trial's over, oh, by the way, here's a little more video. Just, have at it with Higgins that, you didn't need that during the trial.
After the trial. And then their expert goes there to get the original video as prearranged with the Commonwealth. And Colleen Crawford's like, what are you doing here?
Listen, the most interesting thing that I find about that issue is that the lead prosecutor now was not literally involved in any of this alleged misconduct. He wasn't around. But he's also, because of the way Morrissey does business, hiring special prosecutors and, people hand out candy, just come on in. We need another guy to try the case. Mm-hmm. He's not an employee of that office. He's a lawyer with a very strong reputation. And that's important. Obviously, to be a successful lawyer in private practice, you need to get clients. You need to develop business. as opposed to a guy like Lally, who's been in the DA's office for 20 years. You're going to go to work the next day. Your salary is the same. You lose a case, whatever. I'm going to be interested to know, I mean, is there a possible conflict for Brendan here in like, what do I do? You know, I'm not one of them. I'm hired to defend this case, but, you know, I don't want to go down with this ship. If there are ethical issues here, do I look foolish defending this? And, you know, Lally's sitting there at the table. Have they talked about this? I mean, when did this come out? I mean, they obviously.
Is that a rhetorical question?
I mean, when they turned over, I mean, Brendan, to his credit, turned over the video of Higgins in October.
Right.
What is that conversation about? Like, why the hell didn't you do that before the trial? What's wrong with you?
Mm-hmm. I wonder now if this makes a little bit more sense, why they would go outside the office to hire somebody, because it was recognized that everyone in that office may have unclean hands.
Yeah, but Lally's sitting at the table with him, and so is the other McLaughlin, whatever her name is, McLaughlin, not whatever her name is. That's not nice.
Yeah, it's Ms. McLaughlin.
Sitting with him. They're sitting there. If Morrissey thought they were involved in something wrong that bothered him, they wouldn't be sitting there.
Right.
So this thing is just, if there's emotion that comes related to the video, related to some of this stuff that we're seeing about, we're talking about with Green, that is going to be a really fascinating evidentiary hearing in support of the motion. And they're going to get their crack at all these people, including Lally, potentially Whiffen, potentially Buchanan, Tully, and Proctor, as it relates to the video issue. I know we're kind of mixing and matching.
That's okay.
Guarino, I mean, this is a just grade A next level shit show. This does not happen in murder cases. You just don't see so many problems, so many oddities, so many so-called coincidences like this that all generally relate to the most basic concept of being a prosecutor and trying a sophisticated case. You're an officer of the court. You seek justice. If you think she's guilty, go get her, but you have to do it fairly. And, you know, turning over evidence is not complicated. It's not hard to satisfy Brady and Rule 14 in Massachusetts and other things. And these people all seem to have an allergy to doing that for some reason. Not Brennan. He's turning over the evidence. My just question is, what does he know and how much is he willing to defend this? I mean, this is a guy who gave a speech a few years ago saying, you know, you get all these inconsistencies and oddities, you can't get a fair trial. I'm not sure I necessarily agree with the phraseology he used, but, you know, it's got to be a little concerning that, you know, you try defense cases and you rant and rave about the government playing games and suppressing evidence and just whether it's deliberate or otherwise. What the hell is so hard about turning over evidence that the defense is entitled to, whether it be discoverable or exculpatory? It's what you do.
It's what you're supposed to do.
It's what you're supposed to do.
You know, that reminds me of those, remember those, the Morrissey letters that came out, you know, when he was ramping up and he started writing letters to the DOJ and Josh Levy's office, and he was like all over the place with, you know, Rachel Rollins hated me and this person quit and you know, was mad because they got fired or whatever. I think it was his first letter. He mentioned the Whitey Bulger case, and he said something like, you know, we had issues, and I don't remember, maybe somebody in the chat remembers what it was, because I can't find the copy of that letter right now. But he said something like, we are very aware of our obligations under Brady, and we have to turn over. That's why you got to tell us everything you know, because we got to turn it all over right away, because Whitey Bulger, Whitey Bulger, Whitey Bulger. And so I don't remember what he was referring to.
Anytime that you're willing to accept a representation, in this case by the Norfolk DA, that they know that their Brady obligation to Karen Reed, all you need to remember is that when those TUI documents were disclosed way back when, which of course, not because they wanted to, let's be clear, because the federal government did a document dump, that when the parties started arguing about that Morrissey's prosecutors got up with a straight face, and I'm summarizing, but basically said, there's no real exculpatory evidence here. And, you know, you can argue all you want, like some of the online people like get into hissy fits over ARCA, but there isn't any prosecutor who's being honest to the process who would ever say with a straight face that the the evidence that was in that TUI dump that was related to ARCA was anything but classic exculpatory evidence that was entirely inconsistent with their theory and thoroughly would have exonerated Karen Reed if the jury believed it.
Right.
That's as classic exculpatory evidence as you could get. And you know, same thing with a lot of the text messages. Stuff that discredits a witness is exculpatory too, in the sense that it's Brady under something called Giglio, which is like Brady, but it relates to credibility. Same rule applies. There isn't a serious person who would suggest that whether you think Proctor's text, they don't prove her innocence. No, they don't. But they
show bias. But they show bias.
Thank you. They clearly discredit him, which is the same thing under Giglio / Brady. And, you know, evidence of motive, bias, and those sorts of things are the most important kind of cross-examination one could have. And to sit there and suggest that none of this is really exculpatory, they lose the benefit of the doubt. I mean, in their eyes, they don't. I mean, like, look at the video that was, again, the inverted video. At a minimum, at a bare minimum, when that was dumped on the lawyers and used in court, which still makes my head hurt. I can't believe that was allowed. Whatever. But what any honest to the process prosecutor would have done, would have said to Buchanan, you know, let's talk about this video. You see that, and, you know, what do you recognize about the video? And he would have said, well, it shows stuff going on in the Sally Port, but the camera is not a true angle. It shows, you know, the reverse angle inverted, and you bring that out on direct. You're honest. And then you might say, again, assuming you're allowed to use this, well, other than that, are the actions depicted in the video, you know, a fair and accurate depiction of what occurred? He says, yes, they offer it in evidence, but whatever. They didn't do that.
Why didn't they get ahead of it? Right. Why didn't they get ahead of it?
Because
Lally that stupid and he didn't realize it? Or were they trying to put one over on everybody?
They tried to sneak a fastball on the inside corner when they thought, you know, the defense wouldn't notice it. And the reason you know that is because Buchanan had no problem, you know, look at that. It's just a video. There's me, there's Proctor. And only when they got kind of caught about this, here it comes where he's, I don't know who that is. That maybe that's not me. That's consciousness of guilt.
Yeah. And that's also extraordinary prosecutorial misconduct.
Again,
I don't know. Maybe.
You see this nowhere in a high-profile murder case. Yeah, I mean, you just don't see these kinds of things. You don't see disappearing video. You don't see suppressed video. You don't see this stuff that you're seeing with Green. You don't see disappearing library video, but only for the 5 minutes that anybody cares about. You don't see cops not look for ring video for neighbors who could literally prove the crime. And then, of course, the press was told that existed. You don't see the cops not take pictures of the car the minute they see it. You don't see them screw up the time of when the car was towed and then say, oh, that's just a scrivener's error, when it actually, the numbers that he screwed up are not even next to each other. So it, like, makes no sense. You know, you don't see cops talking about balloon knots and things like that, or talking about bullying the medical examiner. I mean, you could go on and on. These are things you just don't see. You don't see a federal government come in and say, we're going to give 3,000 documents over, including what we believe is credible evidence that, you know, from very wonky scientists and engineers, that this is probably not a car-person collision. You know, you don't see taillight pieces recovered over the course of 3 weeks as the snow continues to melt. You just don't see that. You don't see police discover a piece of taillight at night and say, oh, you know, Mr. Slate's blowing the whistle, time to go home. You know, it's 5 o'clock somewhere. Let's go get a few, and then not come back the next day and find the rest because the supervisor says, no, we found what we found. We're good.
Yeah, just drive by on your way home, guys. Just drive by on your way home to and from work.
You
And,
don't
if you see anything, if anything reveals itself as the so mounts, pick it
You
up.
just don't see that. You don't see the butt dials that everyone has. It's like a problem. You don't see,
No
all
crime
these
scene
people,
photographs,
all
lost
these,
cameras,
you don't see, stop and shop bags, solo cops, this,
leaf
that.
blowers,
Just
not securing the scene, no chain of evidence, no chain of custody logs, no logs of who's coming in and out of the scene, no scene log. I mean, as I've been going over more and more cases in Massachusetts, it's becoming evident to me that they really do know how to do an investigation. They really do record witness and suspect interviews, even all the way back in 2020.
Everything that is surrounding this is just this case is such a horrible example to be high profile, for people to be introduced to how the criminal justice system works and to watch it on court TV or wherever they watch it and think that this is how trials generally happen. It's not. This is not normal. This is not how trials are generally conducted, both in the courtroom and, with all the screaming lunatics who get triggered about everything. And, they're going to clip this up later and, say that we're grifting and whatnot.
Boy's already in here saying, go grift.
I mean, it's like the word of the year, right? Is grift. But no, none of this is normal. It's just not. Yeah. And
you are actually being gaslit. You are actually being gaslit into believing that all of these things are just coincidences and have nothing to do with the fact that John O'Keefe did not get hit by a car. Because that is really, at the end of the day, the only thing that matters. And if 227 happened, the case falls apart.
See, I don't even go that far. And this is another thing that gets people all upset.
Yeah, go for it.
Go with the reasonable doubt thing. It doesn't have to have happened. It has to be plausible. That's it. Mm-hmm. If this is plausible, this is one of the few issues in the case that if the DA does not wipe out, they are in serious peril. Because if this is plausible, then it's also plausible that Jennifer McCabe lied. And then they start looking at it again. I don't want to be repetitive, but with the butt dials, with the, she's telling him everything. What a weird thing to say, right? They're looking, but they're over in the Asian guy's lawn. What a weird thing to say. Tell him the guy never came in the house. What a weird thing to say. Remember, these are people that were in a house just having a party who did nothing and then all went home. And they're having a hell of a lot of time plotting and planning to make sure we don't get blamed for that, when the most logical thing would be, my God, our friend died. What do we do? How do we help?
Right. Showing up at Lang's house the next day, showing up at Proctor's house another time. There's a man passed out in the snow.
Listen, on that, when you see the body camera in like real time, what's happening?
Yeah.
Understanding that people can react differently to, stress or whatever.
Yep.
Jennifer McCabe is very cold, and I don't mean literally from being cold outside. She never identifies him as her friend John, never has any panic. He's a guy, a man. And what's fascinating is, what do you think happened? I mean, your first thing, anyone who's truly worried, would be, how do we try to save this man's life? And obviously you're going to try to do CPR like Karen did, all that, but you're going to want to get the cops there. Okay. And when you call 911 and you say, there's a man on the lawn.
Man passed out in the snow. He's not just passed out.
How about, there is my friend, a Boston police officer.
Officer down.
Dying on the lawn. If you do that, there are cops coming all over the place. The whole neighborhood's going to get, even Brian Albert might have been woken up by that if they had said that it was, a police officer.
Maybe not in Hampshire County if you live where Brian Camp lived, but that's another story for another day.
I mean, there's just a lot of real odd things that, the defense, I assume, is going to put together. It's going to be, that you have to marshal for a summation, you get it out at the trial, but you put this all together and you're talking about reasonable doubt, and you spit out the word reasonable doubt about 30 times in the summation of what it means. I mean, it's powerful.
I think Alessi is a great addition to the defense team, and this is his writing. So we love a little New York snark and some Orwellian unpersons. I think he is what he said in the original motion. All right, so it's uncontested that the 12922, 22740 AM search artifacts for Hosslong to Die and Cole found in record 4028 is in a deleted state. And then he goes on to describe what a deleted state is and manual post-imaging manipulation of the data. But then what I find really interesting, here he says, remarkably, the associated documentation containing the hash value needed to validate the image was not provided with the initial USB drive containing the forensic image of Jennifer McCabe's cell phone. This was incredibly unusual. In all of my years working as a forensic examiner, this is the first time I have ever received a forensic image of a phone without the corresponding hash value.
Again, even just that alone is another one of these oddities, coincidences, bizarre things that doesn't make sense, that just happens to happen in this case and is not in isolation. None of this makes any sense. I mean, how could it be that the first time that this doesn't happen is in a case where it's a high-profile murder case? There's obviously, let's remember something else. They had to really fight like hell over Jen McCabe's phone. It was a big deal. The defense,
it went up to the SJC.
I mean, this was a big deal. So the prosecution knows this is a big one. Okay, we don't want to give this up. And as you just said, they fought like hell at multiple court levels to prevent it. And they lost, and the defense got it. And so their response is, for the first time, at least in Richard Green's career of however many years, he gets it in an unusual format.
Right. And it says here, just let me point out that they extracted it with Gray Key, and it was given to Green from ADA Lally by way of Trooper Guarino. So again, Lally's got his hands in this. Guarino gives it to Lally, who gives it to Green.
Lally's hands are on everything, whether he did it. He's responsible as the prosecutor for all this, which is why he has to testify. But this is, I like to reference Columbo all the time. This is like one of these classic Columbo little things. It's like one of those things you'd flag in the back of your mind. It doesn't prove anything, but this leads you to be suspicious. And then, when you come down the list and you see other things and you combine them, I mean, what is the, dare I say, logical conclusion? For those in the attic who are going to be listening later, use logic when you have all of these oddities and coincidences and other things happening. Maybe not to offend people, because I don't want to intimidate, but sometimes when it does walk like a duck and quacks like a duck, it is a duck.
It's a duck. It's a duck. Let me just thank some people for gifting. SB gifted 5 memberships. Thank you, SB. And thank you, WTF Mass, for gifting a membership. And then we have some more gifters tonight. Got a lot of gifters. Lori Life 360 for the win. Gifted another 5. Thank you, Lori. You're always so kind and generous. And Midnight Mike gifting a membership. Thank you, Mike. We'll get to some of these questions after. Chris, thanks for becoming a new member. And the Goodmans are here. And the Goodmans gifted a membership. Thank you so much. And Lori Lake, thank you also for gifting a membership. Moving on, Richard Green was having none of it. So he personally insisted that the MSP provide the hash value associated with the data. And he says eventually they were given a PDF containing the purported hash value, and the value listed within that PDF matched the Gray Key image file of the cell phone in question. However, as Mr. Whiffen even acknowledges in his report, the Celebrite program cannot validate the data because the value is unsigned. In other words, the Gray Key image of Jennifer McCabe's cell phone could have been manipulated, then rehashed after the manipulation, and still show the same resulting hash value included in the PDF.
And that underlined sentence or couple of sentences will be probably the most important part of Ian Whiffen's cross-examination. And no matter what he says about how this can't be, even he will have to concede that, but I'm working with certain factual assumptions that I can't account for. And this goes back to, the whole thing about whether, the blood alcohol extrapolation.
Oh, yeah, we didn't even get to that.
Same idea. you have to, in order to even accept that test, you have to count on, Proctor telling you the truth about what was said about the last time that she consumed alcohol. Are you willing to do that? I suggest you probably shouldn't. This is another example of something like that. In order to accept what Whiffen is saying, even if he makes perfect sense, if that's your belief, there's a huge flaw in wiping out the defense theory, because you can't account for what happened. And later you're going to find out, they had the phone for 2 hours before they started doing stuff.
Right.
And with all the other stuff going on in this case, that again, the oddities and coincidences, does that somehow tilt the needle again towards plausible? Not happen, not like they do it on Twitter. Happened, didn't happen. Like they don't acknowledge how a trial works. This is a huge fact that gives the defense theory so much plausibility, which is really all they need.
And he even goes on to that witness's credit, by the way, the witness from the hospital, the gentleman who came in to testify about the extrapolation. He's like, listen, this is not what we do here. This is not supposed to be used in court. To his credit, he was not going to fall for that. He was not going to lie or even stretch the truth. He's like, it's not what we do. I don't,
right.
Not what we're supposed to be using this stuff for. Here, typically, Green says, after validating the hash value, I typically would then accept that the data has not been manipulated if I got the raw image file and the associated hash value documentation together. Here, however, the hash documentation was not provided with the raw image of the cell phone. Instead, it was withheld from the defense. Withheld. Again.
No, well, I laugh because, look, there's no secret here, people. Lawyers write affidavits and they confirm with the people that sign them that it's accurate.
That's right.
So that way, but that's lawyer writing. The same way about not turning over the exculpatory evidence, the footnote. I mean, that's lawyer writing.
Exactly, and that is what lawyers do. The witness does not draft the affidavit. The lawyer speaks with the witness, and then they draft the affidavit together, and then the witness will review it to make sure everything is correct, see if they want to add anything, change anything, and that is how. It is no shock or surprise in shock and horror, but this is how affidavits are drafted.
Well, you saw
everywhere.
Cross-examination at a hearing about, you had somebody help you write the report. It's the same idea with this. That's nonsense.
And Green goes on to say, as a forensic examiner, having received hundreds of image phones over the course of my decades-long career, this was unprecedented. And then he goes on to say, in addition to them not giving me the hashtags, hash values, there were additional anomalies within the process data that are suggestive of manipulation, as reported by tools such as Celebrite and Axiom. And here are the anomalies.
So this is what lawyers call death by 1,000 cuts. I mean, this is not shock and awe. This is just slice. And I mean, this is.
But it's like, you wanted it. You asked for it. You made this motion. Now you're going to get it.
When you look at this, I mean, he's showing you why it's more than likely that it was at 227, and they just, all they have to do is show it probably was. It's possible. It's reasonable. And these things that we're about to talk about, this is not good for them. I mean, this is bad.
Being kind. This is like bombshell. Like
I'm calmly ranting and raving, as one of my, attackers was calling me the other day when I was having a very civilized conversation about the case. But, so lest I be ranting and raving, it is what it is. This is a powerful affidavit. It is what it is.
I don't find you to be ranting and raving ever.
No, I'm just laughing at people who
I don't follow that stuff, so I don't know. But they're all watching, so hey, what's up? Hit the like button on your way out. Thanks. Here's what he says. These anomalies, including some of the other ones that I'm going to say below, tell you about below, including law enforcement's failure to properly document the chain of custody of items of evidence, inconsistencies in official reports and testimony regarding the collection of evidence, law enforcement's failure to properly photograph and document the evidence, and the destruction of other crucial electronic data are all suggestive of post-imaging manipulation. So let's go down and look at the anomalies, because this is where it gets real interesting. Anomaly number 1. So these are the things that are just unexplainable, unusual. The most up-to-date version of Celebrite Physical Analyzer, which is the INSEAD's version, reports on Jennifer McCabe's phone 4,560 searches, with only one search being marked as deleted. The only search marked as deleted in the most up-to-date version of Celebrite Physical Analyzer is the Haas Long to Die in Cold search found in browser state DB record 4028. This strongly suggests that this search was targeted for deletion.
Well, strongly is
I know.
one could say, statistically speaking, that's as powerful as it gets. And again, so let's use that word for those who are, in the back of the attic, logic. Let's use logic that we always like to talk about, logic. They analyzed this phone with, the most up-to-date Celebrite, and everyone agrees Celebrite is it.
I mean, but this is the most up-to-date version that Whiffen was emailing Green about.
This is, you got to use this.
Right.
And so they find a lot. I mean, that's a lot of searches, by the way, but maybe it's not. I don't know how long she had the phone, whatever. It doesn't matter. There are over 4,500 searches. And on one occasion, there is a magic deletion, which the prosecution is going to tell you with their experts just happened organically. And however the tech wonks would say, phones eventually just delete themselves or whatever. Okay. 1 in 4,560. Would anybody ever take a bet on that in anything in life?
It's not looking good. Magic 8 Ball would be like, all signs point to no.
So what that also suggests is that this is fertile cross-examination for Jennifer McCabe. So you don't delete any searches, right? You're not a deleter. Okay. But you're aware this one says it's deleted. I didn't do it.
I always tell the truth.
Okay.
I'm a very honest person.
I mean, that's powerful stuff for the jury, and in a summation, and say, remember, we don't have the burden of proof. They do. Okay. And they have to establish that this didn't happen. And she had 4,560 searches, and the only one that just happened to be marked as deleted, which their experts are going to tell you just happened organically as part of however
spontaneous deletion,
just happens to be the one which blows this case out of the water, establishes her perjury, establishes that, these people were covering up something, whatever that may be. And more importantly, establishes that, Karen Reed's not guilty. Right. This is a tough one for them. And it's their own software. I mean, this is kind of like rubbing their nose in it a little bit. Good luck.
It gets even better because here's anomaly number 2. The tab ID for record number 4028 is this number starting with AE and ending with a whole bunch of numbers that ends in 53E. This number is unique to the tab in question and would have been used for all URL history in that specific tab within this particular database. The Commonwealth has claimed that the actual website being visited during this period was hockomocksports.com. However, the tab ID recorded at 2:27:36 a.m. associated with the hockomocksports.com web activity has a different tab ID number, which isn't even close, by the way, to the other tab ID number, because if you look at them, this one is AE, blah, blah, blah. This one's CFO, blah, 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 blah.
Guessing that's not a scrivener's error?
Nope, not even close. It's not even like they're consecutive numbers or letters or anything.
Well, neither were Proctor's scrivener error, but I got you.
Right, yeah. Thus, the records in question clearly established that the hockomocksports.com activity was conducted in a completely different tab than the search for Haas Long to Die in Cold, which also showed activity at 2:27 a.m., just seconds later. That argument about how, you opened up you were searching Hockomock Sports and, it reverted back from your 623 search back to the Hockomock Sports tab is now just been, debunked.
So the key for them is to dumb this down. I mean, I understand because we've been talking about this and we heard some discussion about this and whatever, we do this for a living. They need to explain this as if the jurors are children, why one cannot be like the other. because that's what he's basically saying, is that these essentially have digital footprints that are unique to each thing, and these two don't match. And more importantly, that this Hockomock sports thing, which I know has been the one they've been suggesting was actually open, has an entirely different and unique number. So this is one hell of a problem. And again, remember, when the lawyers sum up, they marshal evidence. If you just had anomaly 1 and said 1 in 4560, you're well on your way. Okay. Yeah. Now you're on to 1 plus 2, not just 1, not just 2, 1 and 2. And you say, is it starting to now appear that it's reasonable, it's plausible that she deleted this and deleted it at 2:27 or thereabouts, whatever it was? Certainly seems that way. And we're only on 2.
We're only on number 2. Anomaly number 3. The Commonwealth's experts, Ms. Hyde and Mr. Whiffen, opine that the 4028 record with the 2:27:40 a.m. timestamp initially would not have been associated with the Haas Long to Die in Cold search. I have examined the multiple writes of the 4028 record contained within the browserstate.db wall file, and in all instances, the URL containing the Haas Long to Die in Cold was present. I see no evidence of the 4028 record containing a different or blank for that field.
That's just putting another pebble on the scale. It may not be as compelling and sound as sexy as the first two, but again, you don't look at 3 in isolation. You've already got 1 in 4560, unique digital fingerprints. Hockomock can't be the right one, and then you add this. I mean, so that scale is tilting again.
Or another nail in the coffin. And here's anomaly number 4. The search artifacts associated with Haas Long to Die in Cold, 2:27:40 a.m. How long TI die in CIKD at 6:23:51 a.m. and Haas Long to Die in Cold at 6:24:18 a.m. are all missing information that would be expected in the history.db file. Mr. Whiffen opines that, quote, the load was likely never successful as it was never populated in the history.db database, end quote. However, the Google search suggestion artifact for how long to digest food appears at 6:23:49 a.m. along with a picture. This indicates that the cell phone in question had internet connectivity at the time of the 6:24 a.m. search and contradicts Mr. Whiffen's speculative suggestion that the load did not complete.
Yeah, I mean, have we heard that, they have poor service in their house or whatnot? She obviously looked at other things, everything loaded, and this one hurts them more because this is one that could damage Whiffen. Again, damage, not that he's lying, but just that the defense is establishing that he could be wrong. His opinion is a little bit off and contradicted by, oh my God, logic again, which will tilt the needle towards them. And if he's saying that, well, this information is missing because it probably never loaded at 6:23:51 and 6:24:18, but it did load at 6:23:49 along with a picture, that would suggest at least 2 seconds before the other search, or not 2 seconds. Well, yeah, 2 seconds, that everything was working fine. And again, you're not looking at this just in isolation. One could make the argument and speculate, well, maybe she lost internet service, like people speculate on Court TV. Maybe Brian Higgins was just, ordering a pizza, things like that. That's not a strong argument. And when you look at the other evidence here, that the phone was working, it's loading pages and things like that 2 seconds before, along with the 1 in 4,560, along with the unique digital footprints, along with the fact that Guarino didn't have the certain initial, discovery, along with the fact they didn't give me the original files, they gave me a PDF of the hash values. You go on and you say, are they at least making a good faith argument that this man should be allowed to testify? Don't lose sight of that. The DA, all of this is being considered in the context that the prosecutor said with a straight face, you can't allow this man to testify because his theory is debunked because I say so.
Ipsy Dixit. And also, this is a big duck you right back to them, because remember, Richard Green, they tried to impeach him on the stand by saying, you lied when you said that how long to digest food was an actual search. You lied about that. And really, it was really just a suggested search. And he's like, oh yeah, I had to, correct my report because, whatever. It is a suggested search. And so they tried to make him look like a liar. So this right here, where he says it's a suggestion, how long to digest food, this is a big duck you.
Basically. You see why they call this Orwellian. I mean, this in the context of preclude this witness on Daubert grounds is such an abuse of government power. I mean, it is just government arrogance to say, don't even let these people put on a defense, because I'm telling you, Judge, trust me, this is debunked junk. The jury shouldn't even be allowed to hear it. And then you see what's going on here. And when you think of it in the context of the Norfolk DA with a straight face is suggesting they shouldn't even have the right to be heard and make this argument to tell the jury there's two stories to this search. It is absolute tyranny. It is Orwellian. Mm-hmm. They should be embarrassed that they tried to exclude him. What they ought to do is cross-examine him, which is ultimately what the ruling will be. But to just, I mean, you're telling the defense they shouldn't even be allowed to put on a defense. As I like to joke, we should just skip straight to sentencing. I mean, they're not even trying to deprive the defendant of her, due process right to present a defense. How
about just a directed verdict without even having a trial? Let's just direct a verdict for guilty. We won't even have the trial at all. Let's just save everybody a whole lot of time and effort. And, that's Orwellian. It's dystopian.
It is.
Anomaly number 6, which they skipped number 5. So I guess they misnumbered here. The knowledge C information for the Hoss-Long to die in cold search appears to be out of order.
That's kind of ironic when they skip 5 and we're talking about something being out of order. But I mean, what?
Knowledge C artifacts typically run a few seconds after the event in question. For example, the P-list time for how long TI die in CIKD, recorded at 6:23:51 a.m., has a corresponding knowledge C time entry of 6:23:57 a.m., which is 6 seconds later. Typically, the knowledge C artifact appears seconds after the P-list entry. However, the 6:24:18 a.m. P-list entry for Hoss-Long to die in cold is followed by a knowledge C time of 6:24:24 a.m., 6 seconds later, for how long TID in CIKD. This is where they lose me because this is so over my head. So maybe you can explain this. The corresponding knowledge C entry for Hoss-Long to die in cold does not show up until hours later at 10:33:35 a.m. This is unusual and deviates from what is typically observed.
I think they're just saying that when data that is entered should have a corresponding entry in some file that I'm not a tech guy per se, within a matter of seconds. And what they're talking about happened at 6:24, which is, or around that time that they claim is the actual search, right? When she actually did it, that again, it's unique. It's an oddity. It just happens, the one at issue that they did just happens to be different, which again, you can say it doesn't mean anything in isolation, but 1 in 4560, unique digital footprints, all this other stuff that you talked about going on. And, you just keep piling on proof and proof. And it gets to the point where this isn't possible that she deleted this. I mean, that's what the prosecution experts are going to say. And again, they'll say it, and maybe they make a really strong counterpoint to this. But the jury is allowed, in America, the jury is allowed to hear the defense speak. They are, in fact, and it's funny because, the prosecution here is essentially trying to prevent the defense from putting on any evidence. I mean, they literally are suggesting that they not be allowed to do this. And that should offend anyone who has any interest. I don't care if you think she's guilty or not in what a fair trial is. I mean, this absolutely is Orwellian. They're correct. You can't do this. You can do it, in the Soviet Union. You can do it in like you said, some dystopian novel. Mm-hmm. But in 2025 in America, in Massachusetts of all places, the cradle of liberty, to deprive a defendant of presenting evidence which clearly favors her and may very well tilt the scale in her favor it's shameful, because
How
again,
about failing to allow her to present it? How about failing to turn it over in the
Absolutely.
first place too?
But the fact that we're doing all this in the context of a motion to say he's not even qualified and shouldn't be heard, I mean, it really is shameful.
Except, when you duck around, you find out. And here's anomaly number 7. Trooper Nicholas Guarino's April 24th, 2023 report shows that he took custody of the phone, meaning Jennifer McCabe's phone, on 2/2/2022 at 12:08 p.m. That was also the day that Karen Reed was arraigned in Stoughton. However, the gray key log indicates that the device was not accessed for imaging until 2 hours later at 22/22/1925:40 UTC, or converted locally as 2/2/2022 at 2:25 p.m. The report also indicates he was given the password to the phone. Nowhere within the report does it explain the time delay between receiving the device and imaging the device.
Yeah, I mean, there's a reason why this is the last point. This doesn't prove anything, but it shows the opportunity for them to diddle with the data, right? I mean,
diddle with the data. That's a great title.
Most cops.
Did they diddle with the data? I'm totally stealing that.
Most cops who get the phones and they want to do things, they do it right away. It doesn't matter literally, again, in isolation, this would not be the most compelling point, but it's in a laundry list of items that shows there was an opportunity for them to do it. There are all these oddities, or what they're calling anomalies, and it all supports his opinion that there was a manual deletion by Jennifer McCabe or the person using the phone, whatever, or that there is literal corruption here in the sense that somebody from the prosecution team, presumably in the state police, diddled with the data.
It was diddled or it was proctored. Take your pick. But what I do remember also is that before Jen McCabe turned over her phone willingly, as she said on the stand, she was permitted to delete all text messages, communications with her daughters before she turned it over. She said, "Oh, is it okay if I delete my messages with my daughters?" And they said, "Sure." And so she did. Meaning all of her text messages with her daughter, Allie McCabe, were deleted.
Well, you say, you're giving her credit that she's telling the truth. There is a failure in police procedure there. Now, it's understandable why anyone, when asked for their cell phone, doesn't want to turn it over. I mean, Tom Brady, right? He took a 4-game hit just on principle. I don't want you seeing my phone, whatever. And, the fact that they didn't perceive Jennifer McCabe at all as having the potential, like they're just going to take her word for it.
Sure.
Now,
yeah, of course.
Putting aside that she deleted messages with her daughter, and God knows what they say or don't say, how do you know that's all she did? And why would you just accept that?
Right.
That's just atrocious police behavior. I mean, you take the phone, you extract it, you mirror it, whatever you want to call it. And then, you know what? You obviously don't disclose things, if you can do that are not relevant and don't matter. But once again, they're just avoiding potential evidence because, she said, "I don't want you to see it." And they said, "Okay."
Because they were going to pin it on the girl, and they already knew that from January 29th. And this is already February 22nd. So, I mean, and she's giving it to her buddy.
It's just not good police. I mean, it's consistent with not looking for ring video, not taking pictures, not doing anything. And it's just another example of them yielding control of the investigation to civilian witnesses, which is ridiculous.
Coincidentally, also the same day that that Julie Albert sent a text to Courtney Proctor saying, "When all this is over, tell your brother I want to get him a gift." Same day that Karen Reed was being marched into court, and Adam Lally told the court, "We have ring video evidence of Karen Reed hitting John O'Keefe with her car," which I believe is what he said. You can correct me if I'm wrong in the chat, during that actual hearing.
I don't know if he said that. And, obviously,
I think he did, because I think I've watched it before, but all right, I'm going to say maybe he didn't say it.
If he did, so, all you people, when you clip this, use the word if. So,
think
if
he
he
might
did,
have said it.
presumably he would have done that because that's what he was told by, people from
Law
around
enforcement.
right. And
Law enforcement say they have. See, Stacy said he did.
now most people would have done this though. Let's assume hypothetically there's video of Karen Reed hitting John O'Keefe or something close to it. The arraignment was on what day? You said February 2nd?
February 2nd.
Okay, so from the 29th, 30, 31, 4 days later, what prosecutor who is a professional makes that statement as part of a bail application, right? Without, in 4 days, in a case like this, and never says to the cops, I kind of would like to see the video. Like,
Right.
Show. Because if the video shows her doing it, he could have described it. Hell, he could have played it at the arraignment if he really wanted to make a circus of all this.
Right.
And of course, the whole trajectory of the case would have changed right away. But to say that, I don't know a single prosecutor who in a 4-day period in a case like this would just take the cop's word that it's on video. Because the question is, what's on video? Well, it shows her car and it shows John. Does it show it? Does it show him get hit? Does it show him stagger on the ground? I mean, any serious intellectually interested prosecutor at that point would say, I need to see the video. I need to know everything it shows.
Right. Before you make a material representation to the court.
Which turns out to be
court.
patently, unequivocally false.
Yes.
Inaccurate anyway.
But it was definitely told to the media.
Yep.
Because I know that the media did report on it.
Right.
And then he goes on to say, it is my opinion based on a reasonable degree of scientific certainty that the 2:27:40 a.m. search artifact for Hoslung to Dying Cold was deleted by either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual. Dun, dun, dun. XOXO, Richard Green. Wait, I thought there was... Okay, then I skipped something because I wanted to go over this one part where he says he uses the most recent version, and he even comes up with a more accurate time. Where was that?
Right.
Where was that? Because I know I saw that in here. You saw it too, right?
I think I did, but I don't remember.
Right. Well, it's in there somewhere. You can take my word for it or not. We have not even talked about yet together. Oh, there we are. The other motion for costs. And really, it's just a motion for costs right now, for those of you who don't know, because the defense scheduled an expert visit, a site visit, if you will, to the Canton PD Sallyport for their expert to fly in from Phoenix to come to the Canton PD Sallyport to look at the system, right? ExacuVision or something. The system in which the inverted video was supposed to be held on a legal hold, supposed to be preserved. And the expert got there, and Colleen Crawford, their expert, who has been donating to Marcy's campaign for many years, apparently that's pro forma in Massachusetts. They all do it. It's just an unwritten rule of...
We got to talk about this later because people have twisted that around. Well, I'll hold it for later on the donations, but
okay, so we can take that later. I have never had an instance where I've hired an expert, and in civil litigation, we hire experts in every single case. You can't really prove a civil litigation. You can't prove a case without an expert, right? Whether it be a medical expert or a accident reconstructionist or some other type of expert that has to go to the site, talk about the defect in the property, something. I have never scheduled a site visit or a factory. They have to go take a look at the factory and look at the equipment, make sure that the equipment was working properly or not properly. I've never scheduled an expert visit and shown up and have them not know that I was coming. That is something that just does not happen.
Agreed.
This never happened to me because I would never, because you're paying your expert in advance to show up, by the way. It's not like, oh, they send you a bill later. It's like, okay, I'm going to need $10,000 up front and then I'm going to come. And then after my report's done, maybe you have, but he's not just showing up without being paid.
Well, it's also, a high profile murder case shortly before trial. And you're talking about reviewing the video from the Canton Sallyport, which could mean everything. Yes. I mean, it could literally mean everything. I'm a little off center. Sorry. Could literally mean everything. I'm looking like, wow, you're like, it could mean everything to the case. So it's arranged and you send the IT director from the office there. And it's just the expert comes in and it's like, I don't know anything about this. What's going on? What are we doing? That barely passes the laugh test, if it does pass the laugh test.
Right. I mean, first of all, 100% they should get their cost back. That seems to be a no-brainer.
Yes and no. I mean, first of all, again, because this case has so many things that you just never see. I mean, I think that motion was filed just to whet appetites for what's coming next. But I've never seen in a criminal case, literally this kind of motion for financial sanctions compelling the government to pay the defense back, to pay their expert. I'll be honest with you, I don't see, given the way this case is going, I don't think the judge is going to have any sympathy at all, other than saying, well, that sucks, do it again.
Really? I mean, I absolutely think 100% this is a no-brainer. She should just sign off on this 100%. You arrange this with the defense for them to send their guy there. He's flying in from Phoenix, and then the guy shows up there and they're like, no, sorry, we don't even know why you're here.
I agree. It sounds terrible. All disclaimers too. I mean, they haven't replied to this yet. So, I mean, certainly they're entitled. I don't know what they're going to say, but I mean, they're entitled to try to offer an explanation that doesn't make it sound like they just stood up the expert. I mean, I don't know what they're going to say, but
I mean, Colleen Crawford met him there.
They clearly knew something was happening because she was there. So,
right. So the whole thing is crazy. And I would have liked to know if he could get any just information on the way that camera recorded now. Does it record in an inverted way now? I mean, he wasn't even allowed to really look at anything, I don't think. I think he took some photographs of it, but I don't think
there's no way it records inverted or it's proper. I mean, the whole timeline at the bottom was flipped around. I mean, everything was screwed up and people are coming in and out of the walls. I mean, it's like, this is such a shit show that this could happen in a case like this. I mean, if it wasn't so serious a case, you'd laugh and say, this is like ridiculous, but a woman's fighting for her life. And also, I know today, like you said, is it's the 28th now. Everybody's celebrating John O'Keefe's memory today. It's not justice for him either, to just have a trial where the investigation is so poor that to the extent you even want to believe there's a viable suspect, that any chance to even go after anyone is essentially torched within, an hour of when they discovered him, because they abandoned the crime scene. And at that point, once they lost control of the crime scene, they lost control of the taillight. There's no way to prove one way or the other. And all these other things, the way they gathered evidence, the way they didn't keep the Sallyport video. I mean, the people that are to blame here for not being any justice for John O'Keefe, if that's where this case is heading. And by the way, if you define that as Karen Reed's conviction, that's where the case is heading. Mm-hmm. The blame there really ought to go to the district attorney's office, the state police, and the Canton police for screwing this up from the jump. I mean, it seems pretty clear.
It does to anybody who has any common sense or logic. Thank you, Cat Lady, for your 5. Thank you, Bill, for your 5. That was a cliffhanger from earlier today, and we came back to finish it off. Kim says, in y'all's professional gut opinion, what do you think the SJC will do?
I don't know, but it's been a long time. It's already almost February. There's a trial that's theoretically starting in 2 months. Mm-hmm. It would help to know whether you're defending a murder case or not, I would think. I'm not obviously familiar with how the SJC works in terms of timelines, but given that it's taken this long, it would suggest to me it's going to be a doozy of an opinion, that there's a lot of time going into it. I would think they would want to accelerate this as much as they can. On the other hand, I mean, they're the SJC. If their timeline interferes with the Norfolk Superior Court, it's pretty clear, whose timeline controls. So what are they going to do? I don't know. And I know what I think they should do, which would make nobody happy, is send it back and order a hearing, which guaranteed would delay it. Yeah. I mean, to me, you need an evidentiary hearing on the jurors in terms of what was going on, not the nature of the deliberations, but did you reach a verdict on these charges or not, just so you're clear. And then I think, in all fairness to the prosecution, the next question would be to the jurors, well, then why the hell didn't you publish it? And, if there's a good answer for that, then the defense, I think, ought to win. But I do think that those questions ought to be answered before the judge makes a decision. Meaning,
I agree. I think that's what they should do. I don't know that they will do that. Right. But I also think that based on the current panel of SJC judges, we have seen them in another case rewrite jury instructions sua sponte without even being asked. We have seen them rewrite Rule 14 entirely, which interestingly, I sent it to you, is going to take effect on March 1st before this trial. And for you, maybe we'll go over this another day, but the new Rule 14 is like 18 pages long, and the SJC signed off on it. And it is all about automatic disclosure, and it specifically speaks to what the prosecution has to do I think, as a direct result of the Karen Reed case. And interestingly enough, Judge Cannoni was like the chair of the committee that rewrote the Rule 14. We've also, so in this case, could they, my opinion would be they may decide to rewrite the jury instructions when there's a multiple count verdict slip,
It's a great test case. I mean, you have a murder prosecution, which is turned into a complete spectacle because, there was a lack of clarity about, a unanimous verdict and what it means on what count. And if you really want to make that really clear and you want to be fair, if they're going to change all that, I don't think they would do it in a case in which they allow the defendant to be tried twice for murder, given what happened. So if that's what's going on, that may tend to slightly favor the defense.
Maybe. Do you have to go? I don't want to keep you if you have to go. I can finish these off. Thank you, Desert Quill, for your 10. Thank you, Siobhan, for your 5. Idiots getting away with this from Ireland. Coming in from Ireland. Deanna, shouldn't Celebrite make a public statement since Ian is an active employee and has made some pretty huge statements regarding their software and not as a representative of the company?
Whatever. I mean, I maybe, but to me, Celebrite is Celebrite. This is not going to affect them one way or the other. They are the gold standard of what every agency uses for cell phone extractions and other devices. And I imagine they don't care. That's just my guess.
They might not care unless their stock price starts tanking and people start not using their software anymore. Then it could be a problem. All of a sudden all these law enforcement agencies are like, you know what? We're going to start using Axiom because they seem to be a lot more accurate and reliable. Million Read Karen March. Thank you, Crooked Halo. There's a 24-hour standout today, I think, at the Canton PD. I don't know. I'm not sure, but there is a 24-hour standout in honor of the memory of John O'Keefe. So, Officer John O'Keefe. So for all of you that are standing out in the cold, keep fighting the good fight. Ms. Jules. Hi, Ms. Jules from Florida. Thanks for the 20. I Googled Guarino. Italian, it means guard, protector. He's protecting the wrong people. Thanks for sharing, Cancun and Dave Matthews Band. Oh, thank you. I'm so glad you enjoyed that. I enjoyed it too. Nick, thanks for the 10. In the second trial, is the defense allowed to refer to it as the first trial?
Previous proceeding, prior proceeding. But yes, a witness can be confronted with prior testimony from an earlier proceeding or on an earlier date. You still can do that, but no. But of course, this is all kind of silly because if you don't think that every single juror that gets seated for the second trial is not going to know that this is a second trial, really, of course they do.
Yeah, they do. I mean, you can't live there and not know. Okay, so Ian Whiffen testified on 617 and Green testified on 621. Thank you very much for that info, Glamis News, and for your 5, period, full stop. Are experts immune from lying on the stand?
Well, no, you don't. There's no expert privilege card that allows you to perjure yourself because you have a degree or expertise. I don't think anyone is suggesting that any of these experts are literally lying or doing. I mean, to me, the only thing that bothers me beyond, one could be right or wrong, is this email from Whiffen to Green. Again, it may not have been nefarious, but it doesn't matter. That is a rookie move and entirely inappropriate, and especially given the likely interpretation of what he's politely saying, which is, my guy, you're wrong. That's what he seems to be implying.
But, they can always say, well, this is my opinion. This is my opinion. I'm not lying. This is my opinion. Thank you, period, full stop.
I don't think these guys are lying. I mean, none of these guys are lying. They're not. Ian Whiffen didn't come in to lie, and Jessica Hyde is not lying. They got, according to Green and the defense, they got limited information, which prevents them from reaching the real issue, and that's going to be a problem.
And I think they testified that they did not get the hash values, right? And so their
that's a
testimony
problem.
is based on not having the hash values.
Right. It's a problem for them. I mean, it's not good when you have the hard proof.
Yeah. Squirty Belly says, I've gone up ski lifts that have gone up steeper inclines greater than stairs, and my health data didn't record any stairs climbed.
So again, if you are like the defense here, I'm looking for Apple Watches. I'm not kidding. Or even an Apple phone. I don't know if a phone actually will do stairs on its own without whatever, but it's true. You can often not get actual stairs unless you go upstairs or you go up a very steep incline for a long distance. And I mean, it happens that you don't. I mean, I've gone on walks up a hill for a period of time, and you look and you're like, wow, they just gave me credit for 2 flights of stairs. That's great. But the reality is there is no way, and people who exercise and use Apple Health data and whatever will recognize that if you go driving in a car on just a minor grade, I mean, I'm not talking a hill even, you're not getting 3 stairs. And if I'm the defense, I'm trying to introduce that into evidence. Maybe there's a crime scene visit there. Maybe there's a video to make. Maybe there's an Apple representative to testify. Maybe there's somebody, who does land surveilling, who can tell you the grade and what it is. I don't know. But if the idea is that the stairs came from just being a passenger in Karen Reed's car and doing this on your phone, that doesn't work.
I think that perhaps if you're on the Stairmaster, I heard somebody say that if you're on the Stairmaster at the gym, sometimes it does not record the flights of stairs, but it does not incorrectly record flights when there are no flights.
But I mean, if I go on an airplane and we're taking off, and I start going like this, until I lose service, am I getting like 9,000 stairs?
What if you're on a roller coaster? What if you're on Coney Island, the old wooden roller coaster? Thanks, Anne Marie, for thanking us and for your 10.
This is one of those things where I think it's a common sense thing. People will understand, but I think you got to get the right jurors.
Thanks, JoJo. Getting 500, but it doesn't mean we don't love and appreciate you both. Oh, thanks, you're the best. DK, thanks for your 10. All 3 people who testified regarding the cell phone data use the same methodology, just different opinions. Why keep one expert out of the next trial, not all 3?
All 3 people who testified regarding cell phones. Which side are we? What are we talking?
So, we have Green. Green is one of them. He's on the defense side, and then the other 2 that you're talking about, Whiffen and Hyde, are on the prosecution side.
Why keep an expert out? Well,
are you saying? Guarino?
Well, no, I think what she's saying is, why would you keep Green out? And the answer is, in America, and where there are 2 sides at a trial, and the defense has a constitutional right to a fair trial, The answer is you wouldn't keep him out because he's qualified and explained, as he did in the first case, his methodology. And the problem here is that the prosecutor is saying, I don't care. He's debunked and wrong, and I say so based on what my experts tell me. So therefore, let's just shove out Green. And I mean, that takes chutzpah. That's something else.
Yeah, it is. Thanks, Casey. What about Hank's defense of Whitey Bulger, who did nothing but attack the DOJ and the FBI? Great point, little misfit. Thanks for the 10. I hope when I grow up, I can present like Mark, says Kat Randall.
Not always.
Do you think Brennan was brought in to get the case dismissed due to lack of investigation with the hope of saving real culprits, says Shelley?
No, I don't know why he's doing this. I don't know why no one has ever asked Morrissey why he's doing this, in the sense of if there's no conflict of interest and, you've got Lally and McLaughlin sitting there, so he clearly doesn't think there's a conflict. Why do you need a ringer? Media, go detect something, ask the right questions. That's the question. They've never asked. They apparently don't care. Taxpayers care. But I don't think he's coming in to literally, make the case go down the drain, and then he can, toast the McCabe's and Alberts that we did it. You're safe. I mean, I'm not. That's too far.
Yeah, I'm not buying that either.
I think he wants to win. He think he might regret it now, but no, lawyers like big cases, and I think he wanted a big case. He's just on the wrong side of this one. It is what it is. I don't fault him for that.
Thanks, Greg. Very funny. Thanks, Kyle. Baldwin was dismissed on ammo, not at the scene. Yet Bev lets this go on and on. Think she's afraid of what's happened and what's all exposed. I don't know. Kyle. A lot of people seem to feel that way. Anne-Marie, what an insult to do they really believe the public is that naive? Putting it mildly. Yes, you are. Thanks for tuning in from Canada, Anne-Marie. Christine, thank you. On top, thank you. Look at Elf, loving us, loving this dynamic duo. Tracy, I can't believe Hank would put his reputation on the line for this hot mess. That's what I'm thinking too. So that's why I don't think he's.
I don't know. I mean, look, he's a skilled lawyer and certainly has a reputation. From his standpoint, my concern would be what comes next. When you're in private practice, reputation is everything. He's going to have to go back to private practice when this is over. And, if this thing goes sideways on his watch, you jump in voluntarily, it's a tough position to be in. On the other hand, he's educated, he's smart, he made a choice. So, that's his choice.
Thanks, Lucy's mama, for the 10. Thanks, Kat Randall, for the 10. Will Leah Foley make a difference in looking into corruption versus Josh Levy's investigation?
I don't know what's going on in there, but the changing of the U.S. attorney literally means nothing to this.
It's very common, right? It happens with most new administrations coming in.
Yep.
Lally's going to slide down his chair and hide behind the witness stand during that dismissal hearing. Thanks, Craig. Who's debunked now? Brennan. Green, probably. Thanks, Gray Space. Kyle, how the hell can the Commonwealth argue prejudice against the state?
There's certainly no prejudice to Green testifying. It's potentially painful in the sense that it hurts their case. But the defense has a right to do it. They still have a right to play. I mean, This is,
It's America still. You're still allowed to defend yourself, right? I mean, you're still allowed to, even if you have to pay a lot of money for it, by the way. Thanks, Angie's Way, for your 10, for thanking us. They're still thinking it's 1984 in the Commonwealth. Glad to see the calling out in this motion with all the deets on the sitch. Why was there a snow outline of a vehicle before her car came in? Great point, Bonnie. We thought it was heated. We thought that's why they took it there.
Months and months ago, I asked this, and the only thing I could come up with is because the video is like take two. I mean,
right.
It was already there. I mean, everything with that video is a freaking joke.
Yeah, it really, really is. That's why he apologized on the stand. He apologized for the reason that I told you before, that how to digest food was a suggested search, not something she actually searched for. Thank you, Nicole. Thank you, Siobhan. I don't know about the O'Keefes. I mean, I don't know what they think or why Crawford is involved in the library video too, says Charlie Lynn. Don't know. Thank you, everyone. Thank you, Angie. Thank you. Any news about the Lexus? I haven't heard anything. Have you?
No. I mean, I don't know.
Magenta, thanks. Ms. Jewel, thanks for your 10 again and for thanking us. Please
By
don't
the way,
redline my chat. What do you mean? You did
the-
good. You did good, Ms.
the
Jewel.
Lexus thing. What do they expect that to lead? I mean, suppose hypothetically, it proves she went back, right? That's their big thing, to see if she went back earlier, like around 5:30. Why does that establish guilt? I mean, I'm kind of lost on why that.
I don't know, because they're going to say she saw him there and then she went back there, so she knew exactly where his body was.
Okay, I get it. That's the argument. That's the speculation. There's no real. I mean, it's a position. Why is that considered so powerful or compelling? That's kind of small potatoes.
I don't know why that, but you know, again, seeing, did I hit him? Could I have hit him? That apparently is a confession. So, I mean, look at where we are. Wendy, thanks for the 20. It's embarrassing to me that we're even still discussing the cell data. It's obvious, selfish, childish behavior. You should be offended by this. Thank you so much for your 20. And then Squirty Belly says, yes, an iPhone with no watch will register stairs climbed. I don't know what that means.
I don't know how to set that up because mine, it only does it when I'm wearing my watch. But
all right. Do you think that the SJC could come back with a new law written at the same time? They could. They could. Will they? I don't know. Christy Mel, can the defense confront Trooper Guarino on the stand with his analysis of the Birchmore evidence? That's a good question.
They ought to be allowed to, because it's not a speculative thing anymore. I mean, it's kind of out there, you know, given the federal case, and he would certainly be allowed to explain that. But given how important he is, and given all the other attacks on his credibility, and most importantly, given what you just learned today in what Green is saying, that he missed this evidence and then I found it.
Mm-hmm.
How do you not allow them to say, this isn't your first rodeo at this kind of thing about, you know, missing evidence of, you know, in situations like this? So I would expect the defense to try to do it. And I think it would be a terrible mistake to literally preclude any reference to that, because that goes to the heart of Guarino's credibility, competence, right, including, or whether he's intentionally doing bad things. I don't know. Either way, you know, he's going to get damaged on cross. That's for sure.
Here's a great point from Nikki. SJC just overturned a conviction today based on the judge not asking enough questions about a potential bias of the jury. The trial judge didn't want to ask about deliberations. Commonwealth v. Vasquez. All right, we'll have to take a look at that. Thank you. I want to.
But I mean, juror bias is the kind of thing that's verboten. So yeah.
Thank you very much, PTSD healer. No, I think you know the answer to that. That's rhetorical. Thank you, Owling Dog Design. Thank you to Peppermint. Thank you to Phoebe Beach. And thank you to Alba Gamer for becoming a new member. And Alert One Systems, thank you very much. I think you have to go eat dinner. I think they're calling you for dinner. Is that what's happening over there?
Me?
Yeah.
No, I'm looking at the Bruins score periodically.
Oh, okay. Is there a clock over my head, or are you staring at me? What was that from? That was a movie that I remember. I get Bev has discretion, but any Yahoo with all these violations would say, case closed. How could she seriously keep this going on? Feeling okay. Given all the shenanigans, how is it that both of you and other attorneys feel that Bev is not corrupt and that her behavior is fairly typical?
Because you try cases, and certainly in criminal cases, most judges tend to be biased, whether it's intentional or not, in the sense that they're skeptical of anything a defendant has to say. And I don't find it like that. I don't get PTSD from seeing what she does. I don't agree with a lot of the things she does. I think there are certain personalities in this case, including the defendant, that she doesn't particularly like, which is, you know, I think regrettable. But I'm not going to sit up here and tell you that she's corrupt because she makes rulings that I disagree with. If you show me evidence of corruption, I would tell you she's corrupt. I can't just say because I don't like her rulings that she's corrupt. I just can't do that.
I agree. All right. Before we go, I have a special message for you guys from Alan Jackson. So let's just play this real quick. This is on the Microdots video. This is a Microdots video. And this has to go along with Karen Reed needs funds. My friends, she needs funds. Here's a little commercial. If you guys want to donate to participate, to have dinner with Alan Jackson and Karen Reed on February 7th, 2025, here's how you do it. Listen up.
JJ, I wanted to take a quick second to thank all of the supporters who have given us so much energy and boosted our morale for so long in defense of Karen Read. Both Karen and I and the rest of the defense team could not do what we do on a daily basis if it weren't for you folks. And we want to take an opportunity to thank you in person, to have a unique opportunity to have a dinner with you, to have a conversation with you, to let you into to sort of behind the scenes of what it takes to build a defense like this, what it takes to continue along the track that we're continuing, to have that no quit attitude at all times. And I'll tell you a secret, it comes from you guys. So I'm looking very forward to meeting some of you in person, to sharing a nice intimate dinner with you, to answering your questions, and really having a dialogue. But the main thing is to thank you for what you've done, what you continue to do. We couldn't be here if it weren't for you. We wouldn't be here if it weren't for you. So on behalf of the entire Karen Read defense team, thank you so much. And I look forward to meeting you in person.
Thumbs up on that video. And also, I'm going to put up the information here if you would like to put yourself in the running to to enter the giveaway. Here's the information. There'll be 2 winners. You have to make a $50 donation. Here is everything. I'll keep it up on the screen so you can come back for it later. We're going to wrap, I think, before Turtle Boy goes on at 9 so that you guys can go over there and watch that as well. Thank you also very much for joining us. Mark, do you have anything you'd like to say in closing before we leave everyone for the evening?
No, I mean, it's just, I mean, look, this is all coming up in the context of whether Green is legally qualified to testify. And I just think that's a shame. I mean, it's silly, it's frivolous, and it strikes me as just a bad faith motion. It really does, and it shouldn't be happening.
So I guess we're going to argue this, or they're going to argue that we are going to watch them argue this on Friday. I don't think, I mean, how can she possibly order a Daubert hearing on this? I don't see how she could, but you know,
I think it's a shame they're having a court appearance in person on Friday for this. I mean, this ought to be just ruled on the papers. I'll submit the answer and spare them the expense of coming, because this is as no-brainer as there is. And you also have the benefit of already knowing what she ruled on Russell. This motion is actually even, more ridiculous than the Russell one when you think of it as Daubert. I mean, their position here is that we say Green is debunked because we say so.
Right. Ipsy Dixit. Thank you, Susie Q, for buying me 10 matcha lattes. And Andrea, thank you so very much for your Venmo for coffee. And thank you, everyone, for joining us this evening and for coming and hanging out with us. And we appreciate each and every one of you. Keep fighting the good fight. We'll just have a little moment of silence for Officer Don O'Keefe on our way out. And everyone, stay cool, stay kind, stay classy. Peace. Good night, everyone. Free Karen Read.
Take care.